My name is Amy Hennon. I am the Director of Advocacy and Financial Stabilization with the Maryland Volunteer Lawyer Service. I want to thank you so much for attending today. We have a really exciting presentation from Professor Rubinson from the University of Baltimore. Before we get started with that, I want to just mention that I would encourage you to follow us on social media. We post all of our trainings online to make it easy to view. It's on our YouTube. We post about all kinds of good and important things on Facebook and Twitter, and you can follow us on LinkedIn. So Professor Rubinson is going to be giving us a really wonderful presentation about professional responsibility when working with clients with diminished capacity. I want to take the opportunity to mention that Professor Rubinson's primary teaching and scholarly interests are in professional ethics and alternative dispute resolution and critical legal theory. He is the co-author of 2 books, Ethical Problems in the Practice of Law, 5th edition, and Family Law Mediation, Theory and Practice, 2nd edition. He has served as the reporter for the Maryland Court of Appeals Ethics 2002 Committee, which proposed changes to the Maryland Rules of Professional Conduct, and he's been the chair of the Maryland State Bar Association Section Council on Legal Education and Admission to the Bar. With that, I'm going to switch the presenter over to Professor Rubinson, who is going to take us through his presentation on professional responsibility. Thank you, Professor Rubinson.
Okay, well, thank you, Amy. It's really a pleasure to do this, and thanks to MVLS for reaching out to me, so I'm able to try to shed whatever light is possible to shed on such a difficult issue that I'm sure the folks who are watching this have struggled with, and I have myself. I used to be the staff attorney in Brooklyn. You might be able to hear my New York accent, in an office called the Brooklyn Office for the Aging through Legal Aid in New York. So I have faced these issues as well and struggled with them. Okay, and I hope that you will send questions. Amy will be keeping an eye on those. I really like to speak in sort of a give and take kind of way. I actually have the easy part here because I can tell you about the rules, but the rules only take us so far. They don't give specific answers in many instances, and wrestling with those challenges is really the core of what this is all about. Okay, so when my son was about, I guess it was around 4 years old, he asked me what I did for a living, and I said I teach in law school, and he said, well, why are you teaching in a school that's lost, Tieti? And as I think about that, I won't discuss the larger implications of that comment, but when we're dealing with issues of clients with diminished capacity, and I guess I can move this forward. Okay. It is an area where so many of us get lost. It's been called the black hole of legal ethics. When I teach professional responsibility and most books who deal with it, sort of the core assumption is that your client is able to direct an attorney regarding the goals of the representation and be consulted about the means to reach them, and that's part of the rules of professional conduct. There's a slide on that. And obviously, when you're dealing with a client who has capacity that is uncertain as to the degree to which they're able to guide the attorney, we have a real problem. And again, I'm sure you're not watching this in order to be told it's a problem, otherwise this wouldn't be worth speaking to everyone about. Okay, so what I'd like to do is to go through the parameters of what the rules provide for in this area, sort of thread through those. These rules have changed, again, because this is such a difficult area. The primary rule, oh, I already did that. The primary rule, and Maryland has this, this long citation now to the rules of professional conduct, It's Rule 19-301.14, or as I like to say, Rule 1.14, which is what it used to be and what it is in the Model Rules of Professional Conduct, the ABA version. This is the main message of that rule. It's called Representing Clients with Diminished Capacity. And the message is this: the lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship with a client who has diminished capacity. This might sound kind of intuitive. At a certain level it is, but this actually, I think, has a lot of implications that need to be explored a little bit. First off, even the name of the rule, and even what this says, diminished capacity, it's an interesting word because it suggests that this is not a binary. It's not that a client either has capacity or does not have capacity, or, as it's often said, is competent or not competent. Or in the criminal law, if there's an insanity defense, either it's the wrong word, but anyway, the criminal defendant is insane or is not insane. So all of those are binaries, but the rules strive to recognize that a client has gradations of capacity. It's not an on-off switch. I'm sure we've all dealt with clients like this. And that's what the struggle is. It's dealing with sort of a continuum of capacity. And I like to think by thinking about that word diminished, you get a lot of what the rule is trying to get at. This rule also sends the message that even if a client has diminished capacity of whatever level, it's not like all bets are off. It's not like, oh, client doesn't have capacity, then I can do whatever I think is best for the client. To the contrary, the message of the rule is you try to approach the client-lawyer relationship with a client who has diminished capacity as normally as possible, as if the client were able to direct you. Now, when I was in practice and had to deal with this, and the population that my office represented were elderly people by definition, that's the cohort that we represented, it was much, much easier to reach out directly to family members who often contacted us about an elderly parent usually. That's easy, but that's not what the rule says. It's a lot harder often, both geographically and in terms of communication, to deal directly with the client who has diminished capacity. And in all of our busy lives, and like I said, I'm not lecturing at you, I lived it. This rule says that's not the way it goes. There has to be a real effort to reach out to these sorts of clients as if they had capacity or full capacity. Okay. All of this is from Rule 1.14. Like I said, that's the main event in the rules of professional conduct that try to provide guidance for representing these sorts of clients. And so the rule has a go at a whole number of things. The first is, what is diminished capacity? So diminished capacity is when a client's capacity to make adequately considered decisions in connection with the representation is diminished. Well, thank you. Circular, like a diminished capacity is diminished capacity, that really takes us far. But the second bullet point goes back to what I was saying previously, that there can be intermediate degrees of competence. Again, and I'm sorry if I'm kind of going over that too much, really crucial to what this rule is trying to recognize. So what sorts of clients can have diminished capacity? The rule specifically mentions minority, mental impairment, or some other reason, covers all sorts of stuff. Obviously children, some sort of impairment of cognition or a challenge in understanding situations. It could be attributable to substance abuse or alcoholism. Obviously, it could be congenital or the result of some sort of traumatic injury. And anything that diminishes capacity can fit into this. I think that the children element of it, given that my practice wasn't in that area, is an interesting thing to consider. The rules recognize, and I think we all recognize, that children have diminished capacity, often based upon how old they are. Infants, obviously, apart from the most basics, don't have capacity to understand much of anything. And then presumably, assuming developmentally, there's a track that is, don't like to use the word normal, that's inappropriate, but is a track that leads to greater understanding of one's situation. Of course, adolescents, in my view, have a lot of diminished capacity. They become irrational and incoherent. But apart from that, this again discusses this idea of a continuum that as a child gets older, again, not always, but the notion of a child getting older means that the capacity goes up. Now, assessing diminished capacity, which is kind of a problem. Well, everything's a problem, but I don't know about you, but when I was in these situations, what kept going through my mind is, what the heck do I know about assessing diminished capacity? I went to law school. I took a psychology class in college to fulfill my science requirement because I didn't want to have anything to do with math. Turns out it had some statistics in it, but whatever. So that's the extent of my knowledge, and that really didn't have to do with that sort of thing. So the rules contemplate, nevertheless, that lawyers are the ones who are supposed to make this assessment. And frankly, we're not qualified to do that unless you have some sort of mental health degree, which some of you might have, or some of you might be mental health professionals, but I'm certainly not. Which raises an issue, a fundamental one, which is before we even get into the issue of representing clients with diminished capacity, how do we even know if they have diminished capacity? And if you look at the last bullet point, the rule does recognize that sometimes a lawyer has to consult, and this is a quote, an appropriate diagnostician. I'm not sure if I've ever heard that word except in this rule, but obviously it's trying to be broad and encompassing mental health professionals. Now that sounds good, of course, but when you're representing a low-income client, getting that kind of guidance is not something that's possible with, snap of your fingers. Apart from pro bono mental health professionals, and some of your organizations might have social workers and others within your staff that can assess these sorts of things better than you can. Actually, in my legal aid office, we did have a social worker. But the rules do contemplate, at least to that extent, that maybe lawyers just aren't able to do this, and it's sort of silly to have them do it. That being said, the rules do give some guidance as to what makes for diminished capacity. Client's ability to articulate reasoning related to a decision. Variability of state of mind and ability to appreciate the consequences of a decision. Substantive fairness of a decision. Consistency of a decision with what a client has valued or done in the past. All of which sounds good. I guess this is a time to mention a few other things about assessing diminished capacity. To deal with what my practice involved, the elderly, there's an enormous amount of, sorry, for some reason, printer has decided to check itself. There are an enormous number of stereotypes about the elderly, call it ageism or whatever, the notion that someone who is a very advanced age might not have capacity or have diminished capacity. I think many of us, in my case, there was a family member, great-grandmother who lived to be 102, and you would often say within my family, yeah, she's 102, but she's just, fine, smart as a tack, which happily in her case was true. But even by saying that, there's an assumption that most people of advanced age do not have full capacity. And that's a stereotype. Unfortunately, many do not, but happily many do. And it's easy if you have a client of advanced age to make assumption about that person. One issue that I'm aware of is the ability to speak or having hearing impairments, both of which have absolutely nothing to do with cognitive ability, zero, zip. But sometimes there's a sense that if someone is unable to articulate words correctly as the result of dry mouth, which could be physical changes, sometimes the result of medication, the two are totally uncoupled. So I guess the message with this assessment issue is to bring to it, and again, I'll speak about myself, a kind of humility insofar as our own assumptions about people. And again, to hit the same point, even people who have Alzheimer's or other types of cognitive decline, it's not like there's a point where bang, the person now is incapable of making decisions. It can vary based upon time of day, weather, changes in medication, all of which Rule 1.14 is trying to take into account. I don't know if there are any questions going through. It's so odd to do this in front of a screen. So much of teaching is kind of back and forth, but anyway.
If anyone has any questions at all, please put them into the questions box. It's especially helpful if you have a particular scenario that you've encountered that you have a question about. I, for instance, have dealt with a number of situations where we have a client who has also has a power of attorney, where somebody else is their power of attorney. And these are always really tricky for us to navigate, especially trying to ascertain whether or not the client has the ability to kind of help me have whether I can have a conversation with the client first to assess whether or not we need to bring in the power of attorney to begin with. So perhaps you could talk a little bit about that.
Sure. In instances where there is a formal power of attorney, or there is a parent who is legally empowered to act on behalf of a minor, this does shift a little bit, because then there is a third party who is legally entitled to make decisions. However, Rule 1.14 does not say that all bets are off at that point. So to defer to a guardian from whatever source of law is, according to Rule 1.4, it's not like you can't reach out to the client directly. Actually, the rule suggests that you do. Now, one thing, and I think it's later on, but I'll address the issue now, that is incredibly hard and people have written about is, and I think in your question was getting at this a little bit, is what happens if you have a client and in your judgment, that client should have a guardian appointed on her behalf, or there should be a power of attorney executed so someone else can work on that client's behalf or have the legal power to do so. And more than a few people have said, wow, sounds good, except now you're someone's lawyer, you're reaching out to a third party to execute a power of attorney. It's unclear whether your client is competent, so you're actually representing a client and at the same time facilitating having that client's legal rights taken away and given to somebody else. kind of a conflict of interest, and some people have mentioned that. And sadly, again, with the context of the elderly, but this is true at all folks who have diminished capacity, sometimes third parties sadly do not have the interests of a client with diminished capacity at heart. There is exploitation. I remember I had a case once, it was an elderly person, but the daughter was a rep payee for her mother. That's when Social Security benefits go directly to her. And of course, she has a fiduciary responsibility to use that money on behalf of her mother. She was using it to fund her drug habit. She had a substance abuse problem. So sadly, there are those issues that might crop up. I have gotten questions about that. So the issue there is, what are you going to do about that? Where you feel there is a guardian who is acting in a way that's not in the client's best interest. In which case, sometimes there does need to be some sort of litigation entered saying that the guardian is not acting as an appropriate fiduciary on behalf of the client who has diminished capacity. So, which is a long-winded way of saying that, sure, if there is an attorney in fact or a legal guardian, that person has the legal right under law to make decisions on that person's behalf. I mean, some of it depends on the scope of whatever the power is. However, even so, Rule 1.14 says you still have to look at the client directly as your client. And speaking directly to the guardian is not something that would be appropriate, or exclusively to the guardian is not something that would be appropriate under Rule 1.14. Amy, I don't know if there are follow-ups to that. Like so much, the answer is it depends, which drives people crazy. Specific situations can sometimes help in working through how difficult how to resolve these sorts of circumstances.
Well, I have a kind of somewhat related, but there was no actual power of attorney in place. But so a couple of years ago, I had a client who had quite a bit of debt that we were working through how to resolve. And intermittently, this is something that comes up, especially with clients who lack capacity, but perhaps their either guardian or power of attorney wants to help them file bankruptcy, and there are issues that are always tricky to work through with that. But the client that I'm particularly thinking about, there was no power of attorney in place, but the client had asked that I also speak with a close friend of his who was helping him kind of manage his finances and helping him kind of get his paperwork together. I wound up getting a very unusual voicemail from this friend, indicating that whatever the client had said about whether or not she was taking advantage of him, and that, you know, she had contributed to the debts that he had, that none of that was true, and that I shouldn't believe him, and that he gets really easily confused. And as you might imagine, that was extremely alarming to me, because that was not a conversation that the client and I had had. So how would you have approached that?
Well, we're going to get a little bit later to the issue of reaching out to third parties, either family members or others. I mean, your client's your client, and presumably the friend or whomever who was, assuming it's true, taking advantage of him, that of course is what the person would say. They would say, oh, you know, don't believe a word he said. I mean, what I would do in the letter and spirit of 1.14 would be to go back to the client and, as best you can, try to get from him or her or they what was their judgment about whether they felt they were being taken advantage of. Now, I know in this instance, the client said, oh, go speak to that person. But you're not a fact finder here. Your client is still your client. And ultimately, I think, depending on how diminished the capacity was of the client, if the client says, no, 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 this person is really helping me, again, I didn't meet the client, but if you felt there was enough capacity there, then I would reach out to that person and for it is trust, but to take what that person says into account. Did you feel that that client, to what degree did that client have diminished capacity? And I don't think you're a social worker or a mental health professional.
So the client had some amount of diminished capacity. The client had plenty of moments of clarity and was capable of articulating their, how they felt about kind of what was going on, and understanding kind of the potential path that we might take to resolve the debt issues. But after receiving this kind of this distressing voicemail from the friend, I went back to the client and said, so I'm not sure that I should necessarily be directly communicating with this friend. Are you sure that this is what you want? And he was certain that this was indeed who I should be communicating with. And I did a little more sort of, kind of questioning to kind of figure out if he was potentially being taken advantage of, and he didn't feel that way. But after a couple of more instances of speaking with the friend, I told the client that I wasn't comfortable talking to the friend because the friend was, I didn't think the friend was helpful to the situation at all. And I told the client that I would much prefer to speak only directly with him, and that if he was having a day that maybe he wasn't feeling quite capable, that was fine, that I would call him back the next day or in a few hours. Often it had to do with the sort of cycle of the medication that he was on. And so, if I spoke to him, usually in the morning was the time of most clarity. And so that we wound up having kind of just timing out things with his medication so that I could have a better sense from him what was going on, rather than have to deal with a third party who I never really got to the bottom of whether or not they were taking advantage of him, but it looked that way.
Of course, it sounds like the friend kind of protested too much.
That was certainly the biggest initial red flag, anyway.
Well, it sounds like you did it by the book. I mean, this is, the choice you made, and I don't know. Let me see what the next slide is. No, actually, what you navigated and the choice you made is to be. This is not meant at all to be critical of what you did. In fact, it's something that made perfect sense that I might have done myself appropriately. What the challenge is using your own judgment, or if you want to put it in this way, substituting your own judgment as to some sort of weird indication on the screen now. I'm not able to get off. Okay. It says my network connection is, I hope you can hear me. But the issue is whether you can sure if I can.
Professor Rubinson, I turned your webcam off. That might help the connection.
Okay. Sorry.
No, it's all right.
My face didn't much to the discussion. So the choice you made was to substitute your judgment, I'm putting it in sort of stark terms, for his, in saying, even though he felt like the friend was someone you could reach out to, in your judgment, he wasn't. So you reached that conclusion, you could reach the opposite conclusion under Rule 1.14, which is assuming the client is telling you this, and assuming you feel at the time of your judgment that he has enough capacity in order to give you guidance. Then the other choice you could have made was to reach out to the friend and use whatever the friend said to help you deal with the client's situation. That's sort of the decision point, obviously, from the story. Prior to that, by the book, where you really work with the client, timed your conversations, were aware of the intermediate level of capacity as a result of his treatment and his mental condition, that's fantastic. It's that one decision point about who to believe, maybe that's the wrong way of putting it, but to have your own qualms supersede what your client seems to be telling you. Again, I'm putting it in stark terms. Excuse me. And that's a decision that, what's right, what's wrong, obviously you have concerns, and apparently that's not the wrong decision to make. It does take a step away from deferring to the client who ordinarily would have full capacity. So if we're someone who you didn't suspect had diminished capacity, and the person said, well, reach out to such and such, to the friend who can give you more background. There are confidentiality issues with that, which we'll get to, but that would be appropriate. So it's making that decision. Okay, and I don't know if you want to follow up more with that.
Well, I mean, I have certainly encountered these kinds of issues a number of times, and so I can keep throwing things out at you.
As I'm sure many of us can. Well, why don't I, please, everyone, please ask questions. Like I said, this is what I love to do, and the conversation that we just had is what brings these sort of rules to life. So please continue to ask or jump in, because that's really what I think is as important as me just going through these rules. Okay. And I will, at the end, set aside time for people to ask questions as well, and continue with them. Let's see. Okay. In addition to 1.14, there are a couple of other rules that come into play. And this goes a little bit into Amy's question. There's a rule about allegation of authority, that is, who makes decisions about the representation. The rule makes a distinction between objectives, call them goals, and means. So clients decide the objectives of the representation, and attorneys should consult with the client as to the means by which they are to be pursued. So the goals are for clients, the means are for consultation. Now, through that, the decision that Amy made actually made a lot of sort of fit within this rule, that there was consultation as to the means, that is, reaching out to the friend. The objectives regarding the debt were clear. So under this, it was a judgment as to what the proper means are. When a client, and this is in the rule itself, when a client appears to be suffering from diminished capacity, then the requirements are guided by the Diminished Capacity Rule, that is 1.14. So this particular rule seems clear enough, although the difference between goals and objectives and means is not always clear. It does recognize how diminished capacity can throw this whole thing into disarray. And then there's communication, which requires an attorney to keep a client reasonably informed. And again, this shows the sorts of norms that a lawyer has to meet when representing a client with diminished capacity. And again, there's a recognition that this requirement might be what the rules call impracticable. I don't know why it's not impractical, but whatever. Where the client suffers from diminished capacity. Now, this is tough. This particular set of rules, the drafters of the rules of professional conduct have struggled with. So what happens if there's an emergency? A client's lights are going to be turned off, you know, the electricity or water, or house is going to be foreclosed. If there's some serious or not paying rent, and is at the cusp of eviction, if there's something that requires immediate attention, what can a lawyer do on behalf of a client with diminished capacity? And as I said, the rules have struggled with that. It used to have a term called a lawyer may assume the role, and this is a quote, of a guardian in fact. No one really knew what that meant. Was it kind of a lawyer taking upon herself the role of a guardian who would otherwise be legally entitled to act on behalf of someone? And it just raised all sorts of issues. So I think this was about 12, 14 years ago. The model rules were amended, and Maryland followed the change that the ABA made to nix this idea of a guardian in fact. Some states might still have it, I'm not sure. So they replaced it with this, which tries to be a little bit more nuanced and doesn't use that loaded word of a lawyer sort of taking upon herself to become a guardian. So a lawyer may take reasonably necessary protective action. And what triggers this before it gets to what reasonably necessary protective action is? So there needs to be diminished capacity. There needs to be substantial physical, financial, or other harm unless action is taken. In other words, this is not something minor, but it really needs to be something major that would prejudice the client's finances or life, physical well-being. And the client cannot adequately act in the client's own interests. Of course, that last bullet point comes back around to the question of assessing whether the client can act in her own interests, but for our purposes, let's kind of put that to a side. And comment 9 refers to imminent and irreparable harm. So not all that, pretty intuitive. You know, when we're dealing with very serious circumstances that are about to happen, where if the lawyer doesn't take immediate action, the client will really suffer bad consequences.
So Professor Rubinson, I feel like this is something that at least I feel like I see all the time, because we're often in a situation where we're faced with a client potentially facing say a wage garnishment,
Right.
and so we might have a client with some level of diminished capacity, but who is otherwise working. And so they're you know with some particular judgment that is either coming or is already been put into place, and then they would potentially face a wage garnishment without you know, some action on our part. So this is something that I feel like I'm constantly looking at.
Yeah, which is why I think folks who represent clients frequently in this area do confront it, which is why there's, call it lame, but at least there's an attempt to try to provide some guidance. I had a client once who had a whole set of papers she came in with, you know, sort of messed up and all dirty and everything. We're looking through it. She said she had a Social Security issue, and we looked through it, and she was about to be evicted the next day. So yes, this, and I'm sure other people who are watching this have encountered this issue too. So the rules do say you can do stuff immediately. And before doing it, you're supposed to, and here's the list, consult with family members, sort of hold off doing anything in case there would be prejudice if you took immediate action. Seems a little inconsistent with the protective action aspect of this. Consult with individuals or entities that can take action to protect the client. Yeah, that might hear my dogs up there, sorry about that. So you could reach out to agencies or other folks who can actually work on behalf of the client to kind of put the situation in a stable sort of way. And here's what we get to the earlier conversation, where you can, it says, employ surrogate decision-making, such as a durable power of attorney, or seek appointment of a guardian ad litem, conservator, or guardian. And those last two are kind of, I don't know if you call them the nuclear options, but those are the biggies that you need to take action to ensure that there is someone who can take action on behalf of the client in order to prevent the client from experiencing substantial financial, physical, or other harm. So all of which is to say that the rules contemplate these as actions. They are not unethical, if you will, so long as you're reaching out to the client as much as you can under the basic principle of Rule 1.14. So you can do this. As to whether you should, it goes back again to questions of the degree of diminished capacity. But the idea is to kind of at least put things in status quo. You know, do what you need to do to be sure the client isn't evicted, or to have a wage garnishment. You got to move. And that's the idea of this. And it's lawyers are empowered to do as little as possible to keep everything stable, if that makes sense. Now, in making that assessment, and this again, I love the questions Amy asked because they're sort of setting a context for a lot of what I'm trying to address. So what reasonably protective actions are you going to take? Well, wishes and values of the client, to the extent known. If it was clear what the wishes and values of the client were known, I'm not sure this whole issue would arise, but presumably if the client is able to articulate some guidance as to what's appropriate, go with that. The client's best interest. This is a huge issue, and again, a lot of people have written about this, because how do we know what the client's best interests are? Sometimes we might want to substitute the client's best interests, but presumably in an emergency situation, no one in their right mind would want to be evicted or have their wages garnished. So usually, hopefully, that decision is fairly straightforward. Respecting the client's family and social connections. Reaching out to family. This was the problem, and social connections. The social connections was the problem that Amy confronted. And the last bullet point is what I mentioned earlier. Intrusion into the client's decision-making autonomy should be to the least extent feasible. In other words, you might need to take emergency protective action, but no more than is absolutely necessary. Again, to keep the status quo. Okay, were there any questions, follow-ups at this point?
I don't see any additional anything coming through. But certainly, I think for me, the involvement of family members is always tricky. And when I am working with clients who we're working on, again, some sort of debt issue, and so this would certainly be from a pre-COVID situation, but the client might come to my office for a meeting and might bring a family member with them, and they want to have the family member as part of the meeting, and so there's always the sort of tricky part about meeting with the client, saying, I need you, family member, to wait in the lobby while I talk only with the with the client, and the family members and the clients never seem to really enjoy this interaction that we have. And I say, we'll come and get you in a few minutes, kind of depending on but I need to have a private conversation first. Normally the client will say, yes, no, I would much rather have the person with us just to help me. But I think it's harder when, certainly the harder situations have been when I have had clients with greater diminished capacity rather than just sort of minor diminished capacity, because it's far more difficult for me to ascertain that whether or not they have the ability to understand or say that they really do want to have their family member with them, and again, we're talking about situations where the potential debt implications are there's some potential financial harm that the client is facing.
Yeah. I don't know. You should be giving this presentation. I mean, you're doing everything that is appropriate. I'm serious. You're kind of taking my thunder away from me here, which is fine. Yeah, I mean, there's the reasonably necessary protective action, which is emergency situations. And note under the second bullet point here, examples of reasonably, it does say consult with family members, but you're raising other issues. This isn't about family members, it's about family memers. I don't know if they share memes or something, but we'll assume that says members, so sorry about that. So this is actually pretty much on point to some of the discussion we've been having. Let's actually skip to the last thing that Amy mentioned, which is when a family member is there, let's say brings a client to an interview. So what do you do about it? Well, Amy did exactly the right thing, which is, although it's awkward, you have to meet with the client first. And the reason why is Rule 1.6, 19-301.6 under the Maryland rules, is the confidentiality rule. And in order to adhere to the confidentiality rule, there's all sorts of exceptions to it, which is very interesting stuff, and it's a PR issue. But for our purposes, an exception to the confidentiality rule is one of two things. One is informed consent, and the other is implied authorization. So if you meet with the client individually and the client gives informed consent, you're good to go. If the client has such diminished capacity that it's unclear to you whether the client is giving you informed consent, there is this idea of implied authorization, which in non-diminished capacity terms actually is pretty straightforward. Won't get into that. But in this context, would a client who didn't have diminished capacity sort of say, of course, this person should be here? That might be implied authorization. Maybe that's sort of kicking the can down the road a little bit. But those are the requirements for Rule 1.6 about confidentiality. Of course, the message here too is confidentiality still applies with clients with diminished capacity. Now, a bit of a tougher one is the attorney-client privilege. Many students, some judges, and others are confused about this because Rule 1.6 is the rule of confidentiality. So if you break that, it's an ethical violation. The attorney-client privilege is a rule of evidence, and they actually have different requirements. They're quite different. Usually they're just thrown into one pod under the term confidentiality or privilege, but they're actually distinct. So with the attorney-client privilege, if you are in a room speaking to a client with a third party there is no privilege. The communication needs to be confidential. An exception is if the third party needs to be there in order to enable effective communication with your client. So the classic example is a translator. If a client can't speak English and you can't speak the language that the client speaks, then a translator's there, third party, no waiver of the attorney-client privilege. But if you get consent from the client to have the third party there, the privilege might be waived, but you're good to go. You just don't want to be on the hook for waiving the attorney-client privilege or facilitating the waiver of the attorney-client privilege. All of which is a long way of saying that Amy handled this exactly right, which is to meet with the client individually to ensure that the client, to the extent possible, either gives you consent or, in your judgment, has impliedly authorized that third party to be there. It's so contingent upon the capacity of the client. Now, it very often happens where, let's say, a client is very close to his daughter and likes to have the daughter there as a support and relies upon the daughter to make all sorts of life decisions. You know, wonderful. That's a great situation. Some of us might have been in that before. Even then, if all of the vibes are, you know, the daughter's great, this is fantastic, she can participate in the representation, even then, it's important to meet with the client separately. Discuss confidentiality to the extent possible, discuss waiver of privilege. There's really no exception to that as far as I'm concerned, unless the person is really incapable of communicating, which, you know, then we're in guardianship territory.
So I have an interesting question that has to do with interpretation. So a number of years ago, when I did work that was when I did a little more sort of family law related work, I had a client come in to the office I was working in who had brought a family member to interpret, and so I said that, you know, what I wanted to do was get an interpreter from the language line service that we use so that I could do the disclosure with the client first, and that if the client still wanted to have the family member there for interpretation purposes or otherwise, that we would do that once I had gotten that consent. And so I get the client back to the office and back to my office, and I get the language line person on, except the client spoke a very unusual dialect. And so the language line service had someone who spoke that dialect that we were able to get on, but this client had a distressing family law situation going on, and in fact was pretty certain that the interpreter was somebody that she knew. And so that was, so even though I can say to the interpreter that they are required to keep the conversation confidential, this was a situation where the client is communicating to me with kind of her body language, etc., that she's really uncomfortable with the situation, so I had to end that call and then only use the family member, which I was not happy with, but also didn't want her to feel really uncomfortable with the translator or the interpreter that we had.
Right. But my answer to that is, what else could you do? I mean,
right.
No, I don't mean that in a sort of standoffish way, in a silly way, but, you know, to have someone listening in on a sort of core privileged and confidential communication who the client was not comfortable hearing, that is unacceptable. I mean, did you feel that the client had diminished capacity at all?
Well, no, but she and I definitely did not speak the same language. So
Yeah.
I, I definitely needed some assistance to, and I wanted to have that conversation privately before bringing her family member in, because it's generally not considered good practice to use a family member as an interpreter.
Right.
But in that case, that was what I had to do.
Yeah. I mean, this happens a lot with our current situation with COVID and all of the confidentiality issues that have arisen through different platforms and things. I'm not a techie and I don't pretend to be one. And folks are struggling with that, appropriately so. But my message always is I'm not going to say you can only do what you can do. It's sort of silly, but there's a certain practical necessity when representing clients where the alternatives are not ideal, but you're not violating an ethical rule if you're making decisions to ensure that your representation is appropriate, that you're maintaining confidentiality, even if sometimes things need to be compromised a little bit because there aren't alternatives. The rules don't contemplate well, need to be careful when I say this. Typically, the rules don't contemplate themselves as impeding effective representation. I hope that made sense. So to the extent there was no way to communicate using that non-family member would be appropriate, I would still use that non-family member for the initial conversation about whether the family member should be in there. Not get into the substance of it. I mean, these are the sorts of decisions where, there's no right way of doing it, but the rules contemplate you have to do things in order to ensure effective representation. Again, I actually was involved with a presentation about this. Dave Panzer has been organizing these actually, about technology and primarily confidentiality in our times, and are some platforms susceptible to breaches? Can we ensure confidentiality? Not always, but we can do the best we can. And we don't want to undermine our ability to represent clients because we're not sure, or the technology is evolving, that things are not 100% confidential.
Yeah. So we have a question that's come through.
Okay.
About, so the agent believes that the client lacks capacity and wants the client declared incompetent, and that this person, as the attorney, believes the client is capable of making certain decisions, certain types of decisions, for instance, testamentary capacity. And the client had suffered a stroke and is occasionally disoriented as to the location, but meets the elements of testamentary capacity and has done and to do a new will. And so this attorney is trying to figure out how to explain to the agent that variability in capacity doesn't mean incompetence.
Okay. Well, sort of stripping this down to its basics, you're representing a client and there's someone else who wants to be empowered to act on behalf of the client. Perfectly fine to discuss the variability of capacity, but you're not representing that other person. You can't give that other person legal advice. If they want to pursue this, that's their problem. They can hire their own attorney. So the message in terms of the rules of ethics is your client's your client. There are specific rules about speaking to unrepresented persons, which would be this other person in this case. So I don't see anything inherently wrong with discussing the variability of capacity. That's not even really a legal issue, but getting into the merits of guardianship and those other things, we're running a fine line between giving legal advice to someone who's not your client.
Yeah.
It's about, my class is 101. Can we go just quickly through the rest of it? Amy, is that okay?
Yeah, no, that's fine.
Okay. Actually, this is, we've covered most of this actually. This is sort of a summary of all of the problems that people face in terms of assessment. We already discussed the problem of seeking a guardian because of conflicts. It's also not always an option with low-income people, and the issue of consulting family members. And if you look through those points, I think we've actually, frankly, hit upon all of these. So the last slide, the questions that have been posed to me pretty much have anticipated this last slide. So I'm open for questions or comments from anybody.
And again, if you've got questions, you can put them into the chat box. Or we've got another one. So the follow-up to the question from before. So the agent handles all of the client's finances, and so this was not for a pro bono client. This was for a client who was a paying client. And so this attorney's bills revealed the creation of a new will, which created the awkward issue with regard to the confidentiality.
So I'm a little unclear when you say agent. Was the agent legally empowered? I know it's not true. Was the agent legally empowered to act on behalf of your client?
I'm guessing that this person was the power of attorney.
Okay, if the person was the power of attorney.
The financial power of attorney.
Okay. Well, that does change things a little bit, because then that person is legally empowered to act on behalf of that person. I'm trying to, I might have missed. Amy, I'm sorry, could you just read the last couple of sentences of that again?
So of the, do you want me to read the original question or the follow-up?
The follow-up.
Just that the agent handles all of the client's finances.
Right, right.
And that because this was for not a pro bono client, but a paying client, the
Right.
attorney bill revealed the creation of a new will.
Okay.
Which created the awkward issue with regard to the confidentiality, which is why the attorney had to potentially kind of explain the difference with regard to incompetence, et cetera, and variability in capacity. The variability in capacity doesn't mean incompetence to the agent.
Yeah. The thing,
sorry. And so the attorney has not sent her bill yet.
Okay. The thing about the rules do deal with this pretty directly, actually, if I'm understanding the question right. And by the way, before I get into it, I'm completely open to folks reaching out to me if they have issues, ethical issues. I do this all the time, particularly on behalf of pro bono representation or those who have legal services organization. I'm actually contacted pretty frequently. If I'm understanding the question right, there is a rule that says it's of course acceptable for a third party to pay a lawyer's bills. However, that has no impact on the attorney-client relationship, both in terms of confidentiality, in terms of everything else. So if you're getting paid by a third party, that changes nothing in terms of your ordinary rights towards the client. It just means you're getting paid by a third party. Insurance situations are a little funky when it comes to that stuff. So in that instance, the bill is the bill, and it should be sent as it ordinarily would. This situation, I think, doesn't really change that basic principle that getting fees paid by a third party doesn't really make a difference in terms of your ethical responsibilities to your client. And if I didn't answer that question quite right, feel free to follow up, or we can talk about it later.
All right. The questioner says thank you.
Oh, you're welcome.
Anything additional that you want to add about?
I mean, when I speak about these issues, and there's a few others in ethics also, it's kind of frustrating. And I think the word ethics really scares people. This is really about professional regulation. Ethics seems that if you're making difficult decisions and you're unsure about what to do, you can become unethical, which of course is pretty loaded. We all want to be ethical. But as lawyers, the rules guide us. Again, they regulate us. Sometimes they mandate things, sometimes they offer advice about it. And I think people freak out, like I'm doing something unethical. And I think the message I'd like to share with everybody is not so much to relax. I mean, these are so difficult and we care about our clients so deeply. But if you're struggling with it, you're probably actually 9/10 of the way there. It means you've recognized the difficulty of these and you're trying to work through it as best you can. And there might well be no definitive answers to these. You're just doing your best. And so the fear many people have of, oh my God, I'm going to be unethical. I kind of put that aside. Like I said, a lot of when I teach PR, the situation that a goal I have is for students to recognize there's the problem. Big issue with conflicts. Some people just don't see when there's a conflict of interest. So in this instance, if you're watching this and if you struggle with these issues, it's not so much an issue of whether you're ethical or not. It's just struggling with what the appropriate thing to do is. And these rules can be kind of mushy. They can only guide so much. In which case, some of this is just left to your discretion and reaching out to people, bouncing ideas off of others, as I'm sure some of you do, is actually permitted by the rules of professional conduct. Confidentiality gives way if you reach out to third parties about how to adhere to the rules. So that's all fine. And that's really, the best we can do with these sorts of situations, sort of come back around to it. It is a kind of black hole. There's such variability. There's so many risks involved. And we struggle through it, and the rules recognize that. So I hope this has been helpful. If not, hopefully it's just not about, gee, this guy just spent an hour telling us how hard all of this is. But I hope at least this has given everyone some parameters about how to approach these issues.
Well, I just want to, Professor Rubinson, I just want to thank you so much for all of the everything that you've shared with us and all of your kind of deep thinking about these issues, because I mean it's something that comes up so often, especially in pro bono representation. In many capacities, and so I really very much appreciate it. Just a couple of minor housekeeping issues, and certainly if there are other additional questions, people are welcome to drop those in the questions box. Otherwise, Professor Rubinson did mention that he is willing to have folks reach out to him and ask additional follow-up questions. But I just want to just do a little bit of housekeeping, which is that if you are looking for the slides, they are already in the they're already in the presentation. There's a handouts section, and so the slides are in there. I also want to mention that if you are looking to take a pro bono case, that if you go to our website, which is mvlslaw.org, you can click on the pro bono portal, and that shows an updated list of all of the cases that we have available right now. It looks like this, and you can select cases based on topic area and county according to your preference. You can say that you want to learn more about a case that you're interested in, and also click share case if you want to send somebody that you think should take that case. We have a couple of interesting trainings that we've got coming up. There's going to be a really good one from our tax group that's going to be talking about worker misclassification, which is a big topic for for workers that are that are deemed independent contractors, even though they're not. We're going to have some other interesting Third Thursday trainings coming up a little bit later in July and August. So stay tuned for those. We will post all of this information to mvlslaw.org/events. If you want to find out more about it, what we have coming up, you can also obviously follow us on social media if you want to hear about these. And then if you're interested in taking any of our previously recorded trainings, and these cover a lot of different topics, this information is all on our website under mvlslaw.org/recorded trainings. Most of these have a case requirement, but we can work all of that out. And then finally, if you're not a volunteer but you still want to be, there is both a link in the presentation to sign up to be a volunteer, and you can also just go to our website to apply to be a volunteer. So with that, I want to thank everyone who attended the training and for the participation, and just thank you so much. And we hope that you have a great rest of your day and a great summer. So thanks so much.